Today, I want to discuss a topic that can be confusing for employers regarding the Family Medical Leave Act, known as FMLA. FMLA is a federal law allowing certain employees the ability to take reasonable, unpaid, job protected leave for family and medical reasons. It also requires that their group health benefits be maintained during the leave. Tune in to today's episode to learn if this law applies to you, and if so, the guidelines to follow.
Welcome to Biz Help for You with host Candy Messer. Entrepreneurs like to focus on the big picture, like profitability, success, and a smooth-running organization. But there always seems to be those little things like taxes, employee compensation, laws, regulations, and more. Now you can get the answers you need in one place. Join us today as we break it all down for you. Now, here's your host, Candy Messer.
Hello and welcome to Biz Help for You with Candy Messer. Thank you for joining me today. If you missed my last episode and would like to listen to the show, links can be found on my social media pages as well as multiple favorite podcast platforms. If you'd like to receive notifications on when my podcasts have been uploaded, please like and subscribe. Today's topic will not apply to some of my listeners, but it is an important regulation to understand. So I wanted to share the details to make sure that employers are aware of their responsibilities when it comes to the Family and Medical Leave Act. FMLA applies to all public agencies, public and private elementary and secondary schools, and companies with 50 or more employees. These employers must provide an eligible employee with up to 12 weeks of unpaid leave each year for any of the following reasons: for the birth and care of a newborn child of an employee, for adoption or the placement of a child for foster care, to care for an immediate family member such as a spouse, child, or parent with a serious health condition, or to take medical leave when the employee is unable to work because of a serious health condition. FMLA also provides certain military family leave entitlements. Eligible employees may take leave for specified reasons related to certain military deployments of their family members. Additionally, they may take up to 26 weeks of FMLA in a single 12-month period to care for a covered service member with a serious injury or illness. Today's discussion will focus on general FMLA only and not go into the additional FMLA for military reasons due to the time constraints for the episode. But if you have any questions regarding how this applies, be sure to check out the IRS regulations on FMLA for more details. Employees are eligible for leave if they have worked for their employer, you, at least 12 months, at least 1,250 hours over the past 12 months, and work at a location where the company employs 50 or more employees within 75 miles. Whether an employee has worked the minimum 1,250 hours of service is determined according to FLSA principles for determining compensable hours or work. And again, if you need to look up FLSA information as well, you can find that on the IRS website. Time taken off work due to pregnancy complications can be counted against the 12 weeks of family and medical leave. There are always questions around this policy, and I want to help guide you in the event that you are subject to the rules of FMLA, so you're prepared in the event an employee asks for time off. First, let me give the definition of work intermittently, which is used many times in the legislation. This means taking leave in separate blocks of time for a single qualifying reason, or on a reduced leave schedule, reducing the employee's usual weekly or daily work schedule. The term periodic visit means at least twice a year. A disability under the ADA is a mental or physical condition that substantially limits one or more of the major life activities of an individual, such as working. Major depressive order, bipolar disorder, Obsessive compulsive disorder and schizophrenia are a few examples of mental health conditions that may substantially limit one or more of an individual's major life activities when active. Let's look at typical questions regarding the FMLA leave. Are there any restrictions on when an employee can take leave for the birth or adoption of a child? Leave to bond with a newborn child or for a newly placed adopted or foster child must conclude within 12 months after the birth or placement. The use of intermittent FMLA leave for these purposes is subject to your approval. If the newly born or newly placed child has a serious health condition, the employee has the right to take FMLA leave to care for the child intermittently if medically necessary, and such leave is not subject to the 12-month limitation. When can a parent take leave for a newborn? Mothers and fathers have the same right to take FMLA leave to bond with a newborn child. A mother can also take FMLA leave for prenatal care, incapacity related to pregnancy, and for her own serious health condition following the birth of a child. A father can also use FMLA leave to care for his spouse who is incapacitated due to pregnancy or childbirth. Does an employee have to take leave all at once, or can it be taken periodically, or to reduce the employee's schedule? When it is medically necessary, employees may take FMLA leave intermittently. When leave is needed for planned medical treatment, the employee must make a reasonable effort to schedule treatment so as not to unduly disturb your operation. Leave to care for or bond with a newborn child or for a newly placed adopted or foster child may only be taken intermittently with your approval and must conclude within 12 months of the birth or placement. Can an employer change the employee's job when the employee takes intermittent or reduced scheduled leave? Employees needing intermittent, reduced scheduled leave for foreseeable medical treatments must work with you to schedule the leave so as not to disrupt your operations, subject to the approval of the employee's healthcare provider. In such cases, you may transfer the employee temporarily to an alternative job with equivalent pay and benefits that accommodate recurring periods of leave better than the employee's regular job. What is a serious health condition? The most common serious health conditions that qualify for FMLA leave are conditions requiring an overnight stay in a hospital or other medical care facility, conditions that incapacitate you or family members, for example, unable to work or attend school for more than 3 consecutive days and have ongoing medical treatments, either multiple appointments with a healthcare provider or a single appointment and follow-up care such as prescription medication. Chronic conditions that cause occasional periods when your employees or your employees' family members are incapacitated and require treatment by a healthcare provider at least twice a year. And pregnancy, including prenatal medical appointments, incapacity due to morning sickness, and medically required bed rest. Can an employee continue to use FMLA for leave due to their chronic serious health condition? Under the regulations, employees continue to be able to use FMLA leave for any period of incapacity or treatment due to a chronic serious health condition. The regulations continue to define a chronic serious health condition as one that, number one, requires periodic visits for treatment by a healthcare provider or nurse under the supervision of the healthcare provider. Number two, continues over an extended period of time. And number three, may cause episodic rather than continuing periods of incapacity. Can an employee take leave for reasons related to domestic violence issues? FMLA leave may be available to address certain health-related issues resulting from domestic violence. An eligible employee may take FMLA because of his or her own serious health condition or to care for a qualifying family member with a serious health condition that resulted from domestic violence. For example, an eligible employee may be able to take FMLA leave if he or she is hospitalized overnight or is receiving certain treatment for post traumatic stress disorder that resulted from domestic violence. Can an employee qualify for FMLA leave when donating an organ to a non relative? Yes. An organ donation can qualify as a serious health condition under FMLA when it involves either inpatient care or continuing treatment as defined in the regulations. Organ donation surgery commonly requires overnight hospitalization, and that alone suffices for the surgery and post surgery recovery to qualify as a serious health condition. Is an employee required to prove that they have a serious health condition? You may require that your employee has to have the proof that they need leave for a serious health condition by having supported certification issued by a healthcare provider. You must allow the employee at least 15 calendar days to obtain the medical certification. If you find the certification is incomplete, you must allow the employee a reasonable opportunity to cure the deficiency. You must state in writing what additional information is necessary to make the certification complete and sufficient, and must allow the employee at least 7 calendar days to cure the deficiency, unless 7 days is not practicable under particular circumstances, despite the employee's diligent good faith efforts. Can you request the employee to get a second opinion? You may require a second or third medical opinion at your expense if you have reason to doubt the validity of the medical certification. Can you request medical records to prove a serious health condition? No. An employee is not required to give his or her medical records. But as just explained, you do have a statutory right to request that an employee provide medical certification containing sufficient medical facts to establish that a serious health condition exists. How soon after an employee requests leave do you have to request the certification? Under the regulations, you should request medical certification in most cases at the time an employee gives notice of the need for leave or within 5 business days. If the leave is unforeseen, request medical certification within 5 days after the leave begins. You may request certification at a later date if you have reason to question the appropriateness or duration of the leave. Can you contact your employee's healthcare provider about their serious medical condition? The regulations clarify that the contact between you and the employee's healthcare provider must comply with the Health Insurance Portability and Accountability Act, HIPAA, privacy regulations. Under the regulations, you may contact an employee's healthcare provider for authentication or clarification of the medical certification by using a healthcare provider. In order for an employee's HIPAA-covered healthcare provider to provide you with individually identifiable health information, the employee will need to provide the healthcare provider with a written authorization allowing them to discuss such information. You may not ask the healthcare provider for additional information beyond that contained on the medical certification form. Must an employee sign a medical release as part of a medical certification? No. You may not require an employee to sign a release or waiver as part of the medical certification process. The regulations specifically state that completing any such authorization is at the employee's discretion. Whenever you request a medical certification, however, it is the employee's responsibility to provide a complete and sufficient certification. If the employee does not provide a complete and sufficient certification or an authorization allowing the healthcare provider to provide you a complete and sufficient certification, the employee's request for FMLA leave may be denied. How often may you ask for medical certification for an ongoing serious health condition? The regulations allow recertification no more than every 30 days in connection with an absence by the employee unless the condition will last for more than 30 days. For conditions that are certified as having a minimum duration of more than 30 days, you must wait to request a recertification until the specified period has passed, except that in cases you may request recertification every 6 months in connection with an absence by the employee. The regulations also allow you to request recertification in less than 30 days if the employee requests an extension of leave, the circumstances described in the previous certification have changed significantly, or if you receive information that casts doubt upon the employee's stated reason for the absence or the continuing validity of the certification. Additionally, you may request a new medical certification each leave year for medical conditions that last longer than 1 year. Such new medical certifications are subject to second and third opinions. Can you require employees to submit a fitness for duty certification before returning to work after being absent due to a serious health condition? Yes. As a condition of restoring an employee who is absent on FMLA leave due to their own serious health condition, you may have a uniformly applied policy or practice that requires all similarly situated employees who take leave for such conditions to submit a certification form that their health care provider will provide that they are able to resume work. Under the regulations, you may require a fitness for duty certification to address the employee's ability to perform the essential functions of their job if you have notified them that this information will be required and have provided a list of essential functions. Additionally, you may require a fitness for duty certification up to once every 30 days for an employee taking intermittent or reduced schedule FMLA leave if reasonable safety concerns exist regarding the employee's ability to perform his or her duties based on the condition for which leave was taken. What happens if the employee does not submit a requested medical or fitness for duty certification? If an employee fails to timely submit a properly requested medical certification, absent sufficient explanation of the delay, FMLA protection for the leave may be delayed or denied. If the employee never provides a medical certification, then the time they take off is not FMLA leave. If an employee fails to submit a properly requested fitness for duty certification, you may delay job restoration until the employee provides the certification. If the employee never provides the certification, he or she may be denied reinstatement. May an employee use FMLA leave when they are unable to work because of severe anxiety? Yes. A chronic condition, whether physical or mental, that may cause occasional periods when an individual is unable to work is a qualifying serious health condition if it requires treatment by a healthcare provider at least twice a year and recurs over an extended period of time. An employee is under the care of a psychologist and attends psychotherapy sessions regularly. Is their leave for treatment protected under FMLA? Yes. Under FMLA, an employee may use available leave when they are unable to work, including being unable to perform any one of the essential functions of their position due to a serious health condition, or when they are receiving treatment for that condition. May an employee use FMLA leave to care for family members dealing with mental health issues who are not able to care for themselves? Yes, an employee may use FMLA leave to care for a family member 18 years of age or older if they are incapable of self care because of a disability as defined by the ADA or has a serious health condition as defined by FMLA and needs care because of the serious health condition. A mental health condition requiring an overnight stay in a hospital or residential medical care facility would be a qualifying serious health condition under FMLA. And family members include parents, children, and spouse. If an employee is a caregiver for their brother who is not able to care for himself, can they take FMLA leave for his care? Maybe. FMLA leave to care for a relative is generally limited to caring for a spouse, son, daughter, or parent. An eligible employee standing in loco parentis to a sibling who is under 18 or who is 18 years of age or older and incapable of self care because of a mental or physical disability may take leave to care for the sibling if the sibling has an FMLA qualifying serious health condition. Can you punish an employee for using FMLA leave? No. You are prohibited from discriminating or retaliating against employees for having exercised or attempting to exercise any FMLA right. Examples include using the taking of FMLA leave as a negative factor in employment actions, such as hiring, promotions, or disciplinary actions, or counting FMLA leave against employees in points-based attendance policies. Can you move an employee to a different job when they return from FMLA leave? On return from FMLA leave, whether after a block of leave or an instance of intermittent leave, the FMLA requires that you return the employee to the same job or one that is nearly identical and considered equivalent. If not returned to the same job, a nearly identical job must offer the same shift or general work schedule and be at a geographically proximate work site, which means one that does not involve a significant increase in commuting time or distance, involve the same or substantially similar duties, responsibilities, and status, include the same general level of skill, effort, responsibility, and authority, offer identical pay, including equivalent premium pay, overtime, and bonus opportunities, profit sharing, or other payments, and any unconditional pay increases that occurred during FMLA leave, and offer identical benefits such as life insurance, health insurance, disability insurance, sick leave, vacation, educational benefits, pensions, etc. How much notice must employees give to take FMLA leave? Employees are required to provide 30-day advance notice if the need to take FMLA leave when the need is foreseeable and such notice is practicable. If leave is foreseeable less than 30 days in advance, the employee must provide notice as soon as practicable, generally either the same or next business day. When the need for leave is not foreseeable, the employee must provide notice to the employer as soon as practicable under the facts and circumstances of the particular case. Absent unusual circumstances, employees must comply with the employer's usual and customary notice and procedural requirements for requesting leave. Employees must provide sufficient information for you to reasonably determine whether the FMLA may apply to the leave request. Depending on the situation, such information may include that the employee is incapacitated due to pregnancy, has been hospitalized overnight, is unable to perform the functions of the job, and or that the employee or employee's qualifying family member is under the continuing care of a healthcare provider. When an employee seeks leave for FMLA qualifying reason for the first time, the employee need not expressly assert FMLA rights or even mention FMLA. When an employee seeks leave, however, due to an FMLA qualifying reason for which you have previously provided the employee FMLA protected leave, the employee must specifically reference either the qualifying reason for the leave or the need for FMLA leave. Is an employee required to follow your normal call-in procedures when taking FMLA leave? Yes. Under the regulations, an employee must comply with call-in procedures unless unusual circumstances prevent the employee from doing so, in which case the employee must provide notice as soon as he or she can practically do so. The regulations make clear that if the employee fails to provide timely notice, he or she may have the FMLA leave request delayed or denied and may be subject to whatever discipline your rules provide. Are you required to tell your employees of the existence of FMLA and their right to take leave? Every employer covered by the FMLA is required to post and keep posted on its premises in conspicuous places where employees are employed, or for virtual employees, provide it directly to them, a notice explaining the FMLA's provisions and providing information concerning the procedures for filing complaints of violations of the FMLA with the Wage and Hour Division. If you willfully violate this posting requirement, you may be subject to a civil money penalty for each separate offense. Additionally, you must include this general notice in employee handbooks or other written guidance to employees concerning benefits, or if no such material exists, you must distribute a copy of the notice to each new employee upon hiring. When an employee requests FMLA leave, or you acquire knowledge that leave may be for an FMLA purpose, then you must notify the employee of his or her eligibility to take leave and inform them of his or her rights and responsibilities under the FMLA. When you have enough information to determine that the leave is being taken for FMLA qualifying reasons, you must notify the employee that the leave is designated and will be counted as FMLA leave. How soon after an employee provides notice of the need for leave must you determine and notify them whether someone is eligible for FMLA leave and that it will be designated as such? Absent extenuating circumstances, the regulations require you to notify an employee of whether they are eligible to take FMLA leave, and if not, at least one reason why they are ineligible within 5 business days of the employee requesting leave, or you're learning that employee's leave may be for an FMLA qualifying reason. The designation notice must also state whether paid leave will be substituted for unpaid FMLA leave and whether you will require the employee to provide a fitness for duty certification to return to work, unless a handbook or other written document clearly provides that such certification will be required in specific circumstances, in which case you may provide oral notice of this requirement. Additionally, if the amount of leave needed is known, you must inform an employee of the number of hours, days, or weeks that will be counted against their FMLA leave entitlement in the designation notice. Where it is not possible to provide the number of hours, days, or weeks that will be counted as FMLA leave in the designation notice, for instance, where the leave will be unscheduled, you must provide this information upon request by the employee, but no more often than every 30 days, and only if the leave was taken during that period. Do you have to provide employees with information regarding their specific rights and responsibilities under the FMLA? At the same time you provide an employee notice of their eligibility to take FMLA leave, you must also notify them of the specific expectations and obligations associated with the leave. Among other information included in this notice, you must inform the employee whether they will be required to provide certification of the FMLA qualifying reason for leave and their right to substitute paid leave, including any conditions related to such substitution, and their entitlement to unpaid FMLA leave if those conditions are not met. If the information included in the Notice of Rights and Responsibilities changes, you must inform the employee of such changes within 5 business days of receipt of their first notice of the need for FMLA leave subsequent to any change. You are expected to responsively answer questions from employees concerning their rights and responsibilities. Can an employee's FMLA leave be counted against them for a bonus? Under the regulations, you may deny a bonus that is based upon achieving a goal, such as hours worked, products sold, or perfect attendance, to an employee who takes FMLA leave and thus does not achieve the goal, as long as it treats employees taking FMLA leave the same as employees taking non-FMLA leave. For instance, if you do not deny a perfect attendance bonus to employees using vacation leave, you may not deny the bonus to an employee who used vacation leave for an FMLA qualifying reason. If an employee's medical condition limits them to a 40-hour work week, but you have assigned them to work 8 hours of overtime in a week, can they take FMLA leave for the overtime? Yes. Employees with proper medical certifications may use FMLA leave in lieu of working required overtime hours. The regulations clarify that the hours that an employee would have been required to work, but for the taking of FMLA leave, can be counted against the employee's FMLA entitlement. You must select employees for required overtime in a manner that does not discriminate against workers who need to use FMLA leave. Can an employee use paid leave as FMLA leave? Under the regulations, an employee may choose to substitute accrued paid leave for unpaid FMLA leave if the employee complies with the terms and conditions of your applicable paid leave policy. The regulations also clarify that substituting paid leave for unpaid FMLA leave means that the two types of leave run concurrently, with the employee receiving pay pursuant to the paid leave policy and receiving protection for the leave under FMLA. If the employee does not choose to substitute applicable accrued paid leave, then you may require the employee to do so. What happens if an employee is mistreated for taking FMLA leave or denied FMLA leave? You are prohibited from interfering with, restraining, or denying the exercise of FMLA rights, retaliating against an employee for filing a complaint, and cooperating with the Wage and Hour Division, WHD, or bringing private action to court. An employee can contact the WHD if you retaliate against them for engaging in any of the legally protected activities. So I know that was a lot of information on FMLA, but I hope you found this episode helpful and that it explained FMLA leave and your requirements as an employer to help you meet the guidelines of the law. If you have additional questions or need to know how to implement this in your business, I recommend speaking to a human resources professional. And if you know others who would find this episode helpful, would you please share my show with them and also leave a review on your favorite podcast platform? I'd really appreciate your support. I hope you can join me for my next episode. And remember, you can connect with me on Twitter, Facebook, and LinkedIn. And my website is abandp.com. This episode is sponsored by Affordable Bookkeeping and Payroll Services. If you are overwhelmed trying to handle all of the financial aspects of your business, ABP is here to help. Contact us today to discuss your needs at 310-534-5577 or contact at abandp.com. My team and I are eager to assist you. Until next time, have a great day.
Thank you for listening to Biz Help for You. Please join your host, Candy Messer, again next time. Have a terrific day.